it's important to recognize that some of the most eminent lawyers and jurists in our country are speaking about the state of our judiciary. And their comments are not exciting. Their comments are not pleasing. For example, a former Chief Justice has publicly declared that our judiciary, especially the Supreme Court, is becoming too predictable. What does that mean? How do you predict the outcome of cases before the judiciary, before the court? And what makes them so predictable? Orientation of judges, known commitments of judges, their records and so on, is what makes it predictable. Now, if this is what judgments are based on and so on, then this country is in very deep trouble. Then I heard this eminent lawyer, Mr. Tachuchikata. And Mr. Tachuchikata says very clearly that the crisis in our judiciary is far worse than the crisis in our economy. What? That's a huge statement. As if you are talking about the crisis in our economy, you are talking about bankruptcy. You are talking about a country which needs more than 128% of its total national revenue to service debt, pay debts, and pay public sector emoluments. Now, if this crisis is less weightier than the crisis in the judiciary, then we have a monumental crisis in the judiciary. And these are not my words. These are the words of somebody who has been a law lecturer for many years and who probably was a teacher of some of the people who are sitting on the Supreme Court today. And his verdict is that the crisis in our judiciary is far worse than the crisis in our economy. Now, I watched the proceedings yesterday. You understand? I watched the proceedings yesterday. And I've also read the report of which you read from one of the newspapers, which says that the Chief Justice was angry. You know, I mean, where does anger arise in the work of the Chief Justice? The Chief Justice's role is to impartially, with other judges of the Supreme Court, interpret the Constitution. Where is anger in that? How does anger arise? How does anger become an issue? So I'm just sitting back and wondering, I mean, where is this anger coming from? Okay. Now, I want today just to dwell on principles. Okay? Just to dwell on principles. Ghana has a Supreme Court only because 32 million Ghanaians cannot sit in judgment over cases. Ghana has a Supreme Court because 32 million Ghanaians cannot sit together to interpret the Constitution. So that power of the people, the power, the sovereignty of the people, has through legal arrangements, including constitutional provisions, been transferred to some category of citizens. So when the Supreme Court actually sits, it sits in the name of the people of Ghana. The Supreme Court itself doesn't have any powers beyond the powers that the people of Ghana have vested in the Supreme Court. So at every time when the Supreme Court is making decisions, it should be asking the important question whether it is truly, genuinely, legitimately acting on behalf of the 32 million people of Ghana. That's the test. So at any time when the Supreme Court acts against the expressed, unexpressed will of the people, the Supreme Court's essence, the essence of the Supreme Court is lost. And we have to understand that very clearly. There's a matter of principle. Okay. Now, the Supreme Court interprets laws, including laws enshrined in the Constitution and so on. Eminent jurists have established a principle of law. And that principle of law is referred to as the purposive interpretation of law. Purposive. And this is a principle which is known by every law lecturer, every law student, every law practitioner. Now, what does the principle mean? That principle simply means that in interpreting the law, the general good of society should be taken into account. So at every time that the Supreme Court sits to adjudicate on any matter, it ought to be asking itself whether indeed that interpretation of the law contributes to the achievement of the general good of society. This is an important principle in law. I'm not the one who is coming up with this principle. Now, there's something else which is absolutely important. The general principle is that the Supreme Court expresses the sovereign will of our people and so on. It has to. Okay. But that sovereign will of our people and so on is embedded in the Constitution which the people of this country adopted for themselves in 1992. Okay. Now, at every time, these judges on the Supreme Court, and the Court of Appeal, and the High Court, and so on, should be asking themselves very important questions. Ghanaian people lost their lives in order to give life to this Constitution. Ghanaian people suffered imprisonment and so on, clear hardships in order to bring this Constitution into being. Now, the question I pose today is whether or not the conduct of judges takes account of the huge sacrifices that the people of Ghana made in order to bring about this Constitution, which makes it possible for us to operate a Supreme Court, and which makes it possible for us to appoint a Chief Justice and Justices of the Supreme Court. The people who struggle for this Constitution, to give life to this Constitution, is this the outcome they wanted? Do they want an outcome such as this one, and so on? You understand? Now, all these are matters of principles which I suspect are not challengeable. These are principles which the legal practice, judicial practice, and so on have established over the years, and I think it's important to apply them at all times. Now, yesterday, after reading the judgment of the 5 justices, I heard the Chief Justice, in a very angry mood, pose the question, why have we come to this? Why is Parliament not sitting and so on? Is that the business of the Chief Justice? Whether or not Parliament should be in session or not is clearly the duty of the Speaker. The Speaker calls Parliament into session. The Speaker is the one who adjourns Parliament, definitely or indefinitely, and so on. What has that got to do with the Chief Justice? In any case, why was Parliament adjourned? Parliament was adjourned because it didn't have the numbers to take decisions. It is not because of the Speaker's decision. It is not because of the injunction which was being sought in court and so on. Parliament simply could not have the numbers to take decisions, and that's why Parliament was adjourned. Is the Chief Justice in any way suggesting that Parliament should sit when it doesn't have the quorum to take decisions? Is that what the Chief Justice is suggesting? And if that is not what she's suggesting, and she's acting in her capacity as a citizen rather than a Chief Justice, and she's entitled to that, perhaps what she ought to do is to advise members of Parliament of the New Patriotic Party not to boycott parliamentary procedures, in order that we shall have the numbers to do business. That's all. And she can do that in her capacity as a citizen. That does not lie in the mouth or actions of the Chief Justice, but it lies in the mouth and actions of any and every citizen. And the Chief Justice indeed has a right as a citizen to make appeals to members of Parliament not to unduly and unreasonably, boycott parliamentary procedures so that we can get business done. And I have no quarrel with that. Now, one of the issues which came up yesterday was the claim that the Speaker's lawyers had not filed their responses to the matter which had been raised by the plaintiffs in the case, and therefore they were unduly delaying the process. Now, I'm a lay person. I didn't go to law school. But listen, what happened in court yesterday was the Speaker, represented by his lawyers, asking the Supreme Court to set aside decisions that it had made. Asking the Supreme Court to take note of the fact that the process before it was improperly filed. So if the Supreme Court had decided yesterday that the Speaker was right, there would have been no case pending before it for anybody to respond to. Okay? Now, unless the Speaker's lawyers believed that the case they were sending to the Supreme Court was frivolous, had no merit, and so on, how could they have filed responses to a matter that they thought had been irregularly brought before the Supreme Court? So I think that the lawyers of the Speaker acted properly and demanded an extension of time to enable them to file, their responses and so on. And yet the Chief Justice was so angry that at one point she actually asked lawyer Sorry whether they should go ahead without him. And I was sitting at home saying, I'm a layman, but this is horrifying. I'm shocked. I cannot understand, what is happening. There's a certain argument which ultimately the Supreme Court may have to decide, okay, on which argument is right and which argument is wrong and so on. That is the prerogative of the Supreme Court. It's not the prerogative of people like me and so on. But you see, ordinary people like me, who have no law certificates, who have no experience worthy of membership of the Superior Court and so on, have something which is simply called logic, the capacity to apply logic. And nothing stops us from applying our logic. Listen, let's take the case of Cynthia Morrison, Member of Parliament, who went to Member of Parliament on the ticket of the New Patriotic Party. Okay. Now she says that I cannot contest elections on the ticket of the New Patriotic Party and I'm going independent. By extension of logic, she's saying that she's no longer loyal to the New Patriotic Party and she's no longer going to push the agenda of the New Patriotic Party. Now, very clever people then say that, that would apply to the next parliament and not this parliament. Very clever people, okay? Now, bless. How is it possible to have divided loyalty? Today, as we speak, she has no confidence in the New Patriotic Party. Today, as we speak, the constitution of the New Patriotic Party makes it clear that she's no longer a member of the New Patriotic Party. So this argument about, she can continue to represent the New Patriotic Party now until 9th January or 7th January 2025. How does that make sense? How does that make sense? The party has no confidence in her. She has no confidence in the party. But by some logic, we say that it is still possible for her to represent a party which has no confidence in her and in which she has no confidence. I'm lost. I'm completely lost. And perhaps I'm completely lost because of the level of my ignorance. But whatever it is, I'm entitled to my ignorance. You understand? So it's strange. Then the other thing which struck me yesterday was the reference to caucuses in Parliament. There are no longer caucuses in Parliament. You know, at the end of the last elections, the NDC had 137 seats and the NPP had 137 seats. So we had a hung Parliament. But there was one independent candidate. So the matter was referred to the Speaker for a ruling as to whether or not we can have a majority caucus and a minority caucus. And I remember very clearly the Speaker giving a decision which says that there are no caucuses anymore and that there's a majority group and a minority group. So where from this majority caucus and minority caucus that the Supreme Court referred to yesterday? I cannot believe it. Okay. Now, Master, it's important because if you look at Article 97, H and G of the 19th Constitution, it is clear that it does not allow crossing carpet in Parliament. That the independent candidate could not have become a member of the NPP caucus because it would have implied that he had crossed carpet and therefore would have had to lose his seat for a by-election to be conducted in his constituency. So the Speaker very cleverly declared the existence of a majority group and a minority group. You understand? Now, I disagree with the Speaker. I disagree with the Speaker on grounds that the standing orders of Parliament envisages a situation where there always has to be a majority and a minority. The reality after the last elections suggests that there wasn't no majority and there was no minority. So what needed to be done was a recrafting of the standing orders of Parliament to fit this new situation. Now, either because of laziness or because of the will to cling to tradition and so on, we still maintain this position of majority and minority and found a very clever, perhaps disingenuous way of declaring one side a minority group and the other side majority group. That is where this problem is coming from. You understand? That is where this problem is coming from. Because if you have an independent candidate in Parliament who declares that for all times, for the 4-year life of Parliament, he will be aligned to a particular party, Master, directly, not indirectly, he has crossed carpet. And we allowed that to happen in flagrant violation of Article 97, H and G. In flagrant violation. Now, yesterday, the Supreme Court also came up with some decision which I found interesting. The Supreme Court says that it has appellate jurisdiction over all judicial cases. Now, this is interesting. Because if you go back, I recall that the Supreme Court itself decided that if you go to the Constitution, the Constitution says that election disputes ought to be handled by the High Court. And that aggrieved parties who are not happy with decisions of the High Court can appeal to the Court of Appeal. And ended there. By the Supreme Court's interpretation of the Constitution, the Supreme Court came to the conclusion that because the Supreme Court was not directly mentioned as an appellate body, appeals about election disputes ends at the Court of Appeal. This is a Supreme Court decision. Of course, they say that this Supreme Court is not bound by decisions of other panels and that you can change them and so on. So maybe they are right. But it's interesting that one panel of the Supreme Court decided that appellate jurisdiction over matters of election disputes and so on ends at the Court of Appeal. And another panel, headed by the current Chief Justice, decides that no, it doesn't end there, it actually ends at the Supreme Court. That's interesting. It's for lawyers and people who know better, to advocate. one thing which was very striking yesterday was also the decision that one of the judges that the speaker's lawyers were asking to recuse himself would not do so because he has been approved by Parliament. And I'm wondering, how does parliamentary approval cure the likelihood of bias? Because there's no person in the world, including myself, who doesn't have a bias. That bias is not cured by parliamentary approval. You understand? How is it cured? You are born in a certain geographical area that itself endangers violence. You have a certain religious faith that itself brings about the likelihood of bias. You are married or not married, that itself also can generate bias and so on. So everything we do, the kind of education we had and so on, our cultural background and so on, all those things can become prejudicial in adjudicating matters such as constitutional interpretation and so on. So bias is not cured simply by parliamentary approval. And yesterday I was worried. I was even more worried when the judges decided that because Gabriel Praman, who used to be General Secretary of the People's National Convention, is also sitting on the bench as a Supreme Court judge, political affiliation is no longer grounds, for likely bias and so on. I was totally confused. You understand? Now, whatever it is, whatever the situation is today, these matters before the Supreme Court need to be resolved. But we should not forget that decisions of the Supreme Court today will become precedent forever. Okay? And that maybe in 2 years' time, maybe in 5 years' time, maybe in 20 years' time, what our judges decide today may become an albatross around our necks. And it's important that we take account of that. As a citizen of Ghana, and I'm speaking as a citizen of Ghana, not a lawyer, not a judge, an ordinary citizen of Ghana, what I expect our Supreme Court and indeed all our courts to do is to act on our collective behalf to ensure that we have good governance in this country. Whatever provision is in the Constitution is intended to achieve good governance. And good governance can only be the sensible and correct management of national resources for the resolution of problems that confront our people. Finish.